And of course, any recording will remove everyone except the invite, the main presenters, so the audience knows. I'm here with the eminent David Grosky, board member and longtime HINDA member, our director, Abigail Rabinowitz, who you all know, Carlene, my extraordinary colleague, and we are here for the introduction to the legal panel. Thank you so much, everyone, for being on time. And I hope you will like this. And if you have any questions, you can text me. And I'll put my number in chat. And Dave Grosky, with that, please take it away.
Thank you, Michael. And it's again a pleasure. Welcome, everyone, to this year's HINDA legal panel for 2024. This is our third year, my third year involved with this panel. We've put together what I believe is a very impressive and esteemed list of speakers on a variety of topics that I believe are germane and timely regarding new developments in the law and ongoing issues of interest. My topic tonight will be discussing two particular advents in particularly federal criminal law involving newly established guidelines and expanded guidelines for compassionate release, and in the federal system, what is called a 2-point sentence reduction. I'll also be alluding to, with respect to Illinois, a certain expansion that has occurred of late in that compassionate release law. But I open it up as well to a discussion of any of you who are involved in other states, and I'm very happy to be helpful if any of you have any other questions on or offline regarding any other states who have similar yet somewhat different compassionate release laws. And these are things I can assist you with if you'd like me to, and I'd be very happy to assist. But before we begin, I would like to, as I have always done historically, begin with our Devar Torah. And preparing as I typically do with Rabbi Shimon, in last week's Parsha, he and I were discussing the Parsha Softim, judges. And in common parlance for our purposes today, it's really a concept of judging ourselves, even though technically, from a Jewish law perspective, it was the appointment of judges that was at issue. But in discussions with Rabbi Shimon and making it more germane to our discussions, it's a time for self-awareness and being able to objectively judge ourselves. And at times, for many of us, when we think we may be too close to a situation, to be able to be objective, to seek out or have an individual near us or one we feel comfortable with that could provide an objective view for us of our actions and our activities, to provide wise counsel, to make sure that we're operating on the straight and narrow. I could tell you from personal experience, and just to digress for a moment, I'm an individual who unfortunately was incarcerated for almost 11 years with a 14-year sentence for a business-related crime. It was a difficult time for myself and my family, to say the least, very challenging, but we all got through it. And today, we're all very, very close in my family. We have as much love as I believe we've ever had for one another, having gone through a difficult experience and come out the better for it in many respects. But during those years, in the preceding years, and then years since my release 5 years ago, approximately 5 years ago, there have been still challenging moments. You know, as you can all imagine, after being incarcerated for almost 11 years, coming out of that experience has taken a lot of adjustment, and it's an ongoing process, one day at a time, of course, where many days are better than others. But overall, I can tell you that there are changes to oneself when you go through an experience like that that are permanent and on a continuing basis challenging. Having said that, I have great support, and I have individuals who I'm very close to in my family and very dear friends who provide me wise counsel and are tremendous examples of both love and healthy support. And that's what we all need. And we don't need many. If we have one or two of those types of individuals helping us with our self-awareness on a day-to-day basis, making sure that we're living the lives that we would like to live, healthy both physically and spiritually, there's nothing much more we can ask than having one or two individuals even that can provide that type of loving support. So with that, let me begin with my topics tonight, which are going to basically center on two subjects. One is compassionate release. And again, I'm going to begin with a focus on the federal system. I will then move into what is called a 2-point reduction possibility for certain inmates for a reduction in sentence. As many of you know, I believe, the sentencing guidelines largely dictate one's federal sentence, and those are all based upon a point system. So in recent years, there's been an expansion of the ability to come into court and argue that based upon certain profile of a particular individual in his or her case, one can ask for a 2-point reduction, which oftentimes, depending on the length of sentence, can equate to months or years off of one sentence. And I've had success in this area, and again, would be happy to assist offline with discussions, including the providing, as I've done with Michael and Carlene. I have templates I've provided to them, which I'd be very happy to share with all of you for your consideration if you yourself or loved ones are in need of this type of assistance. So let me begin with a discussion of compassionate release. And within that context, let me say that, and before we began tonight, I was discussing this a little bit with Michael. Historically, the BOP was loath and very slow in moving on providing inmates with an ability for early release. Why? Because, as we all know, prisons are big business. And while the prison situations in those years was becoming severely wanting of additional need for money to run the prisons, nevertheless, and with the ability, by the way, in those years, for the prisons to make a decision to allow people to be on home confinement or in halfway houses earlier, they nevertheless, for the most part, and very rarely allowed people to go home early for any reason. But in very recent years, I would say in the last 2 to 3 years in particular, that is now changing, and it's changing for the good. And these expansions that I'm going to be discussing tonight are giving judges greater latitude and deference in being able to provide inmates with an ability, particularly to be released to home confinement earlier, based upon particular, I'm sorry, Michael, you have a comment? Okay. Particular issues, focusing primarily still on medical. And when I say medical, not only of the inmate himself or herself, but of the inmate's immediate family. And historically, the medical issues only pertained to oneself or children. But now there's been an expansion in two critical areas. One is there's now inclusion of one's elderly parents, which is not an uncommon phenomenon, where an inmate's parents are elderly and suffering from medical conditions, where if it can be established that the inmate and only the inmate can be the caretaker for that parent or parents, in other words, that there's no other family member, sibling or otherwise, that can care for the ailing parent, then that particular inmate is a good candidate for early release to home confinement to be living with that parent and assisting that parent in their daily medical need caring. In order for that to succeed as a practical matter, and I've been through many of these instances now on behalf of inmates, it's critical that the inmate, when filing a motion for compassionate release, does not simply present himself or herself this particular situation to the court. What is necessary is that in addition to that, an expert report, namely the report of a treating physician of that particular parent, is provided to the court. Why? Because, as we all know, the typical prison's view of an inmate's request on these type of things is viewed as completely self-serving. And without the assistance of an objective third-party expert, it's not going to typically be taken very seriously. And it's not just a question, I would tell you, of having an expert letter written on behalf of the ailing parent. That letter has to contain certain information to be effective. And this is where I've run into some complications because, as you can imagine, many of these treating physicians believe they know how to write the letter. not knowing that it's more of an art than a science in this setting. And so I've been met oftentimes with reluctance to have input from myself or another attorney into what that letter content is going to include. So it's very important that the professional, whether it be me or someone else, provide that particular individual with the doctor, I should say, with specific information of what the content of that letter has to generally provide in order for it to be effective. Digressing again, I do want to say that I am an attorney by background. Prior to going to prison, I was a practicing attorney in the Northern District of Illinois for almost 20 years, practicing in commercial and bankruptcy litigation. I did not involve myself in any type or have a significant understanding of criminal law until that 11-year time in prison, when I was doing a lot of assistance to federal inmates throughout the country in the prisons that I was in, pretty much on a daily basis, where that assistance continues both through the Hinda Institute on occasion, but also through continuing contacts that are made to me through these prisons based upon these individuals making referrals, having known me when I was in prison. But at this point, when I'm working with the Hinda Institute, and I want to say to all of you, I'm very happy. I don't charge a fee. Once I say to you, I'm going to be helpful to you. Any way I could be helpful to any of our attendees this evening, absolutely free of charge with both documents and the law, I will be as helpful as I can be to you and your family members. I just want to make that very clear. So getting back to compassionate release. So the second avenue of expansion that is of material note is that historically, an individual inmate, in order to be released into early home confinement based upon a medical condition, would have to be terminal, essentially, with a letter from a treating physician saying that individual suffers from a terminal disease or illness, and the likelihood of that individual living more than weeks or months, not even a year, is necessary for that type of release to early home confinement. That has now been expanded more broadly to any debilitating medical condition that could lead to an early demise or early death. That's much more expansive, as you can see. But also there's a secondary and maybe even more significantly common scenario, which is where an individual is suffering or laboring under a particular medical condition, and that individual is being treated at the prison, but can demonstrate that the treatment that he or she is receiving is inadequate as compared with, from an objective perspective, what he or she would be receiving if he or she was on home confinement and being treated privately at a hospital or by a private physician at home. I've had some success in this area, and what's necessary to be able to establish there to have success is to be able to gather the medical records from the prison, which are maintained on a regular basis. Again, provide those to an expert treating physician on the outside. Have that treating physician opine with a letter that is going to be ultimately an attachment to the motion for compassionate release as an exhibit that states that if this individual was home, he or she would be receiving the following treatment for this particular debilitating physical condition, and that in comparison to the treatment that that individual is currently or in the past has received in prison, that existing treatment or past treatment is wholly inadequate as compared with the treatment that he or she would be receiving if under my guidance, with specifics as to what that would look like. And that all of those specifics, all of those particulars are necessary to make a necessary showing for a judge to be able to feel that the credibility has been demonstrated to warrant early release to home confinement for compassionate release. Before I continue, any questions of anyone on any of those items? Okay. Now, the expansion federally of compassionate release does not just relate to medical issues, though, either. It can relate to an additional expansion, which involves what is called unwarranted sentencing disparities, or a change in the law where if that individual inmate was sentenced today, the sentence would be materially lower, or likely materially lower, than it was at the time. These are another couple of fertile areas that I've seen successful, particularly where the changes in the law in the areas of what is called the 924C charge, an attendant gun possession charge in narcotics cases, where it can be established that the individual who had the gun possession was not either aware that the gun was involved in the particular conspiracy because he or she was not in actual possession of it. And instead, and it's a legal term, they knew or should have known constructively that one of their co-conspirators had a gun. But because they didn't have actual knowledge, they certainly couldn't be deemed to have been involved in a matter of dangerous activity, if you will. Because of this has opened the door for individuals to be argue that their crime was overstated at the time based on some of that change in the law in the 924C area, and by virtue of that, they are entitled to consideration for early release based upon the fact that if sentenced today, their sentence could very well be lower or lesser than it was then. So that's just another example, in addition to a catch-all that says any extraordinary or compelling reason. And that of course is broad. That can be as much as a person who's done a lot of time, has not had any disciplinary infractions, has done tremendous amounts of programming. And these type of considerations, along with some of the others in the totality, could allow a judge to say, you know what, that person served enough time, let's get him into early home confinement. The message I want to leave with all of you this evening is what Congress has now done with these expansions, what the Sentencing Commission has done with these expansions in approving them in 2023, is provided judges with a far more broad basis to be able to provide individuals with a real opportunity to be placed on home confinement earlier. And for the first time in many, many years, I'm seeing on more regular occasions, individuals who on regular occasions would only receive 6 months to a year of home confinement, being on home confinement up to 5 or even more years. That's not something that many of those individuals would like, but I can tell you they would like that more than being in prison. So that's a positive on that score. Let me move now for a moment to the 2-point reduction. Oh, well, before I do, actually, let me say in the Illinois context with respect to compassionate release, before I move to the 2 points, staying on compassionate release again, that Illinois too has somewhat broadened. Governor Pritzker approved an expansion several years ago now, and I've been involved in a couple of cases on this where there's been a further expansion, again, allowing for those who have a terminal illness but cannot establish, based upon an expert physician letter or the like, that individual only has weeks or months to live. That again, if the individual can establish that the condition is debilitating or fatal, likely fatal, I should say, but with no timeline necessarily attendant to it, that could be a successful route as well in the state of Illinois. So I want you to know as well, for those of you, and I know many of you are, either have loved ones who have been incarcerated in the state of Illinois or know of those who are, there's a further opportunity there for those individuals in the state system. Moving, as I say, to the 2-point reduction in the federal law, the 2-point reduction for federal inmates essentially applies to those with either a minimal or no criminal history, where by virtue of that, they have 0 what's called points, security points, meaning they're at the lowest level of risk, both in terms of being a danger within a prison environment, but also from a recidivism analysis perspective once they're released. And because of this, with the exception of certain types of crimes, which we can outline, many offenders, many inmates are eligible for a 2-point reduction. And that 2-point reduction, as I said at the outset, can be a reduction in a matter of months or even years, depending on the length of sentence. I've seen individuals with a decade or more of time receive a 1 or 2 year reduction in sentence with a 2-point reduction, which is significant. And I can just list the criteria generally that one must meet to be able to satisfy the 2-point reduction statute. One, the defendant has not received any criminal history points. That the defendant has not received an adjustment for terrorism. That the defendant did not use violence or credible threats of violence in connection with the offense. The offense did not result in death or serious bodily harm. The offense of conviction is not a sex offense. The individual did not commit an offense where individuals lost what is considered to be a substantial amount of money. Now that's an interesting one. I've worked with certain individuals who don't have individual victims. They have company or corporate victims only. And then the question becomes, what constitutes a substantial loss? And the case law is pretty much all over the board, depending on the state on this. But I can tell you that for the most part, anything exceeding hundreds of thousands of dollars, the courts will view as a substantial loss. So as a practical matter, in most of these cases, any loss is a substantial loss for this purpose. Now, having said that, I can tell you that the most significant chances, if you do have a financial crime, are in instances where you have an institutional loss, not individual personal losses of victims. And the latter is the more common, frankly. So that is a challenging area right there, I can say. In addition to that, the defendant did not possess, receive, purchase, transport, transfer, sell, or otherwise dispose of a firearm or other dangerous weapon in connection with the offense. The offense of conviction is not an offense involving individual rights. The defendant did not receive an adjustment under Section 3A 1.1 involving a hate crime or vulnerable victim crime or a human rights offense. And the defendant did not receive an adjustment under Section 3B 1.1, aggravating role, and was not engaged in a continuing criminal enterprise. So as seen with this criteria, the legislators included various requirements before an individual is eligible for this reduction. For individuals that are still facing a pending prosecution and have not pled guilty or yet been sentenced, it's critical that criminal defense counsel focus on this criteria during the negotiation phase to make certain that, to the extent possible, they preserve these rights post-sentencing. With all of that said, I did provide Carlene and Michael with examples of both compassionate release motions that I've prepared generically, without the names, of course, of the individuals to protect their identity, as well as example of 2-point reduction motions. And I'd be happy to provide any or all of you with those, in addition to, if you'd like me to, assistance in any particular state where someone you know or a loved one is involved in a case now where either or both of these concepts might be helpful to them being released earlier than otherwise. That would be it for my presentation this evening on these two concepts and these two issues, and I open the floor up for questions or comments.
Or if you could give us some examples also, David, that might help us also.
Examples of those who benefited from them?
Yeah.
Okay, so I've been involved with an individual in the past who was at Terre Haute Camp in Indiana. He was suffering from a severe case of asthma and respiratory ailments, and he wasn't getting his breathing treatments on a regular basis at the local hospital. He still was in contact with his treating physician. As I mentioned earlier, critical that we received a letter from the treating physician being able to outline not only the importance for this individual to receive particular types of breathing treatments using certain types of equipment on a regular basis, and if not, what the likely or very possible result of that and consequence of that would be for his health and his long-term survival. But in addition, what this particular physician specifically recommended needed to be done, and if not done within the prison system, how it would be of significant benefit to this individual if he was home receiving treatment from this particular physician. That was a successful outcome for this particular individual. There was another case that I was involved in 3 years ago where, which began then, but then culminated more recently with a successful motion for compassionate release, where this individual was able to establish through affidavits of his family members that he was the only caretaker for his ailing mother, who was suffering from a very severe case of multiple sclerosis, was wheelchair bound and unable to care for herself, was in her 90s, and there was no other family member who could care for this individual. So we were able to establish, again, both through affidavits of family members and then again, treating physicians, that without daily care for this particular family member, the parent, that this particular individual is the only individual capable of assisting, and that if there was no one to assist and there were no financial means otherwise without, for the family to opt for an alternative, that this person's life ability to live much longer was very, very limited. And that ultimately was a successful case. Where those cases fail is where the family cannot establish that there's no one available. If there's even one person available, the government will seize on that, and the judge will almost always suggest there is an answer other than the inmate being able to provide for the parent. There has to literally be proof that there's no one else. Either there is no sibling living in the state, a sibling living in the state who can absolutely prove that they, for a variety of reasons, cannot care for the parent. It does get tricky. It's detail oriented, but you have to have all your ducks in a row to have a chance for winning those type of motions where there's an ailing family member. Questions, comments? And to let you all know, the First Step Act is related to it. I think all of the above in many ways, I have to say. There's always, as I said earlier, been a financial problem within the BOP, and yet they never acted on any of this. So I think it was really a combination and a boiling point, I guess, through the aggregate of all the issues you mentioned, coupled with the financial issues, maybe even coupled with the upcoming election, although I have to say it preceded this. I mean, it's been going now for 2-3 years before this election. But I really think it's more of, you also have these groups like FAM and others that have been pushing for the last 5 to 7 or 10 years. And traction is beginning to really take hold. And I actually think that over the next 5 to 10 years, we're going to see a lot more alternatives to incarceration pushed. And ultimately, I think there's going to be a lot more people in the system on home confinement than ever before. What they also needed to do, almost in a sense, as a pilot program, is experiment with what's going to happen. What is the result within the system of individuals being on home confinement for 5 or more years? That historically was never the case. What does that look like in society? And what they're finding already is a positive result of that, but they weren't sure going in. So because they're seeing positive data and positive results there, I see it growing and continuing. And I think because, again, especially with the elderly populations, it's a tremendous cost savings to put people home sooner. And of course, they're going to get better care at home. That's just logical. So, yes, Mike.
Yeah, thanks, David, for that very thorough presentation. And while I'm really glad that you helped bring us some good news about some movement towards remediation or alleviation of prison conditions, very long sentences, particularly in the Fed, although there's many states also have pretty long ones. What I also notice is at the same time, there are an awful lot of carve-outs. And I understand that this is a natural, normal function of a legislative process. And, but the more carve-outs there are, obviously, the smaller the number of people. And, I'm wondering if there's any kind of a movement, and I don't know if you know the answer to this question or not, towards, I don't know how to put it, a more holistic method of approaching risk assessment in assessing the inmates who would otherwise be eligible for such considerations.
Well, I want to say this as an overriding issue that I've toiled with through the years. And as we all can see, one of the common areas of criminality that is continually focused upon in these exclusions is sex offenses. Now, my problem with it is that the courts, by and large, in the federal system anyway, have consistently viewed the sex offenses as violent crimes. The problem I have with it, though, is the great majority of those offenses, and I'm not defending them, but I'm just explaining my view. The great majority of those are what we'll call computer-related offenses. And it was always difficult. I could never accept intellectually how one can conclude, a judge or otherwise, that a computer viewing of something is violent. And yet, in these exclusions, it continues to be followed in that fashion. And I think that argument has not been supported enough that I've just articulated on that particular issue to really gain ground. I think that would be the one area potentially because let's face it, that's an area where the exclusion just, continues to be, most widely adhered to, without further definition.
Can I just respond to that very good insight? Will the audience give me a moment to follow up, if you would, please? So I really I appreciate that, because I think that is an important distinction. And as old Hinda people may remember, there also used to be a white collar group. And what I learned from interacting with that group, people who had been convicted of financial crimes and often had very heavy financial fines to pay in addition to their prison sentences, is that these are people with years of expertise, MBAs and, significant experience that they could use if they were given the opportunity to provide expertise for businesses to become better businesses. And it always seems so self-contradictory to deny people with expertise in business the ability to access lines of credit, for example. Now, it goes into another thing having to do with banks, and that's not entirely a legal thing. But again, it's this issue of how do we assess real risk in dealing with inmates? So we want to protect the public, but then are we really understanding where the risks are, and in terms of mitigating excessive sentences or fines on the one hand, and alleviating overcrowding in prisons versus protecting the public. And I think we just need to do a better job on that.
Well, and that really also hits on the need, in my view, for individual assessment per case rather than the lumping people into a category. In the financial crime area, for instance, when I was sentenced, it was at a time when Bernard Madoff, and there was a case in Minnesota, Tom Petters. These people were receiving 150, 50, 75 years. And it was almost became a sentencing of emotion for these judges. And that's exactly when I was sentenced. Today, with the same sentencing guidelines, I can tell you, because I watch these cases to this day, I'd be getting half the sentence with the same sentencing guidelines. It really doesn't make any sense. So what happens is if you're unlucky enough to be sentenced at a particular point in time, you're oftentimes lumped in with particular people with quote unquote similar cases, but are they in fact similar? And there's a lot of times more dissimilarities than similarities. And actually I want to say that too, with respect again to the sex crimes. There isn't a distinction drawn between computer-related cases oftentimes in many respects and non-computer related cases. And in my mind, there needs to be, from a variety of perspectives, including research that's been heavily done over the years on the risk of recidivism on each one of those areas of those particular crimes, where on the computer crimes, the recidivism rate, people don't realize this, is tremendously low. on the
Right.
computer-only case. A lot of people don't realize that.
I would encourage you and anyone else interested in that particular topic, not only to look at the research of this guy in Arizona, I can't remember his name, but I could get it for you anyone's interested, but also the second appellate response to Judge the late great Judge Weinstein of Southern New York on
Okay.
that topic.
Yeah, yeah.
Yeah, I have a question.
Yes.
I'm here on behalf of my son,
Okay.
who couldn't make it, who is now.
David, David, there's two more hands up here. I don't know if you see them.
I
One-
just saw Svetlana, but
Yeah, there's Debbie Campbell and there's Steve Sand. So maybe start with Debbie and then Steve.
Debbie, I'm sorry I missed you, Debbie. Hi, Debbie.
That's okay. I just put my hand up like a couple of minutes ago.
Okay, okay.
I just wanted to thank you for taking the time to do this Zoom tonight. And because I also work on compassionate release, your presentation, the information is very valuable and spot on at that. Everything that you talked about, or mostly everything that I'm aware of, is right on. And thank you for sharing with everyone. It's very important that people are aware that compassionate release in prisons is available now.
Thank you very much.
And a lot of people do get it. So
yes,
I've seen many people go home.
It's important to support people going home early, and it's important to me to be supportive of people, to try to do our best and fight to try. We can't control the outcome always, but I always would say to people when I was in prison, and I was busy all the time because I really didn't charge any money. I would say, if you can even give me a cup of coffee for my time just to be respectful, that's enough for me. So needless to say, in a prison, you're busy when you're doing that. But the point was what it did. You know what it was? And as long as you're not giving false hope, you're providing hope.
Yes.
How important is that in that environment?
It
might
is,
not. I didn't win often, but I won enough.
It is.
You know what? You know what the issue? But all these people had real hope when they had lost hope. That's important.
It's funny you should say that, because I'm kind of going through that right now with my job. It's like, unless you've experienced it, most people don't understand that aspect of hope. So a lot of times, instead of, giving prisoners the hope, they're afraid to, because they're afraid it's false hope. And I'm like, no, that's how we survive in there, is by hope. If we didn't have hope, we'd have nothing. So,
I would always say, Debbie, even in the context of a 2255 post-conviction appeal where the chances might be at best 5%, I would say to someone, I think your chances are 5% at best, but we have a 5% chance of hope.
exactly.
That's how I put it.
Yeah, exactly.
Now, with the compassionate release, if you have the right situation, it's far greater than that, thank God.
Yes, it is. Absolutely.
Well, thank you so much, Debbie. Thank you.
You're
Steve?
so welcome. Thank you.
This is a Swedish prison. But let's talk about Europe in general as basically the guideline for, and I'm not comparing that to Talmudic or Torah-based approach, but it's an approach that's working in Europe, and we know it. We've known it for many years. A much different type of system. In fact, I was incarcerated with an individual I'm still friendly with, who was incarcerated, as we've talked about tonight. In this country, the politicians control everything. It's the political parties, sadly.
David, I just want to say it's fantastic. And we really want to thank you and Mike for doing a fantastic job. And the next speaker is going to be Elizabeth Kelly on mental health law. She's very good. And after that, we're going to have a new one called Mr. Hirschman, who won the case against IDOC with Denton's Law for their flagrant mistreatment of people in prison. So that should be quite interesting.
Two very esteemed, wonderful speakers. I think you'll all enjoy very much.
Right, and David will be facilitating, so we can see David again with his good Taurus.
Thank you. Well, thank you all so much. Thank you all for staying throughout the entire session. And we look forward to seeing you next Wednesday. Thank you.
Thank you, David.
Thank you.
Thank you, Michael, Carleen, and Ann.
Thank you, thank you, thank you.
See you guys.
See ya, Mike.
Bye-bye.